Hey everyone, today we are discussing a topic that's all about resolution, compromise, and avoiding the stress and expense of a courtroom battle. We are talking about settlement agreements, what they are, where they come from, why they matter, and how they work in real life. So if you have ever been in a dispute or might one day find yourself in one, this video could be a lifesaver. Let's begin. Let me tell you a story. Two neighbors in Singapore, Mr. Tan and Mr. Lim, had a dispute over a tree. The tree's roots were growing into Mr. Lim's garden, damaging his tiles. Angry letters were exchanged. Lawyers were engaged. Things were escalating quickly. But before they ended up in court, the lawyers arranged a sit-down. After some back and forth, both parties agreed Mr. Tan would trim the roots, pay for the broken tiles, and Mr. Lim would drop the claim. They both signed a settlement agreement. And just like that, no courtrooms, no judges, no hefty legal bills. So what is a settlement agreement? It's a written contract where two or more parties involved in a dispute agree to resolve it, usually by making compromises, instead of fighting out in court at a trial. The idea of settlements go back centuries. In ancient times, even before we had formal courts, people would meet under a tree or in a village square, hash things out, and shake hands. Today, we have the modern version, a formal legal document, drafted carefully with terms everyone agrees on, often saving time, money, and emotional energy. Let's make this real. Here are three everyday scenarios where settlement agreements are commonly used. First example, Sarah, a marketing executive, was wrongfully dismissed. She alleged unfair treatment. Her company denied it. Rather than letting it drag through the Employment Claims Tribunal, they entered into a settlement agreement. The company paid her 3 months' salary as compensation, and she agreed not to sue, and both parties walked away. The settlement agreement included a non-disparagement clause, so neither side could badmouth the other. Second example, a supplier failed to deliver goods on time, costing the buyer thousands of dollars in losses. The buyer was preparing to sue, but during pre-lawsuit negotiations, both sides agreed to a settlement. The supplier paid part of the loss, and the buyer agreed to accept future deliveries at a discount. The settlement agreement avoided months or possibly years of litigation in the courts. Last example, a divorcing couple couldn't agree on property division and maintenance, also known as alimony. Instead of letting the court decide everything, they sat down with their lawyers and drafted a marital settlement agreement. They divided the assets fairly, agreed on child access, and the terms were later recorded in a consent order by the family court. Last example, a company director sued his former business partner in the High Court, claiming breach of fiduciary duties and seeking damages. The defendant, the former business partner, made a counterclaim alleging wrongful removal from the company. The parties went through mediation at the Singapore Mediation Centre. After 2 days of negotiations, they reached a confidential settlement agreement. The plaintiff withdrew the suit and the defendant discontinued the counterclaim. Both parties agreed to bear their own legal fees and move on with their separate business ventures. The settlement brought a swift and quiet end to what could have been a drawn-out public commercial dispute. The key in all these examples, certainty, closure, and cost savings. Now let's talk about what goes inside these agreements. Here are the most common clauses found in a Singapore settlement agreement. The settlement sum or consideration clause spells out who pays what, to whom, and by when, i.e. the deadline. It could be a lump sum or installment payments. Second most important clause, a release clause. Now, a release of claims clause ensures that both parties agree not to pursue any further claims, whether past, present, or future, relating to the dispute, i.e. there is closure. This proves finality. There's also usually a no admission of liability clause, which states that by settling, no one is admitting fault. It protects reputation. Next, a confidentiality clause is often included, where parties agree not to disclose the terms of the settlement to anyone. This is very common in employment and business cases. Many settlement agreements also include a non-disparagement clause, which prevents parties from making negative public comments about each other, common in employment and partnership disputes. The governing law and jurisdiction clause specify which country's laws apply to the settlement agreement. For Singapore agreements, this is usually Singapore law and the Singapore courts. An entire agreement clause makes it clear that the settlement agreement overrides all previous discussions or drafts. Finally, the most important clause, the default or the breach clause. It sets out what happens if a party fails to perform their part of the settlement agreement. For example, if someone doesn't pay on time, interest kicks in, or in the case of installment payments, the whole sum will immediately become due and payable instead of staggered installments. And here's my view as a lawyer, someone who has seen too many people waste time, energy, emotions, and stress fighting when peace was possible. Settlement agreements reflect reality. Most people don't want to be in a prolonged legal fight. It's stressful, it's expensive, it's emotional, and even if you win, the costs, emotional, mental, and reputational, may not be worth it. Settlement agreements offer something courts cannot always provide: control. You control the terms. You control the narrative. You decide what is fair. And in today's world, especially in Singapore's fast-paced, pragmatic environment, time and peace of mind are priceless. So if you ever find yourself in a dispute, consider a settlement. It's not a sign of weakness. It's often a sign of wisdom. Thanks for joining me in this video. I'll see you in the next one.